And the legislature changed that, and that statute has changed as we're sitting here today. Another one was involved cops and what I call crooked cops case. Kitsap County had tried to fire a crooked police officer, and it went through arbitration, and they held that he couldn't. You can't even fire a crooked cop. And I wrote, no, that is not right, and if it is the law, it should be changed. And ironically, the sponsor of the same law he was earlier alluding to on the disabilities, they changed that law too. It's common sense, isn't it? But it's common sense, it had to be written into a law change. So I think I've had, well, 700 and some cases. That's a lot of cases to sit on, and 140 that I participated in writing and deciding, but I've been there for every one of those cases. I read every brief in every one of those cases, and so I'll tip my hat to them. Of those 700, there are probably, I don't know, 2,000 to 3,000 briefs. I've probably read 16 BIW briefs too. But in that volume of work, let me tell you, it doesn't change your mind. What changes my mind is the two constitutions I have in front of me, and then reading the law. And I think that's an awful lot of experience to put aside. So I think on an accelerating level, I'm adding a lot to the court. And I hope to be able to do the same thing in the next 6 years.
It seems to me, sitting here listening to you guys, that you both have excellent resumes if you were applying for a job in a law firm. But most of your arguments have been about stuff that the public doesn't care about. What have you got to say? Why should the public care which one of you gets elected? Why don't you go first?
Sure. I think that sometimes the judicial branch of government is the invisible branch of government. People don't understand what happens in the courts until they need it. You know, I deal with people who come to me with crises in their lives, who've never talked to a lawyer, never had any litigation problems, never been to the courthouse in their lives. And then, all of a sudden, it's a problem. And that person needs to find and look up at the bench and see a judicial officer that is prepared, that is knowledgeable, that is ready to apply the law as it's written, and to give them a fair shake when they come in there. That's why it is important who is on the court. Whether that be the trial court or the Court of Appeals or the Supreme Court, it is important who our public servants are. I'm a little amused at my opponent's statement. He goes to work every day. I don't know how you get by without doing that. I certainly would be out of business if I didn't go to work every day, and a lot of times that's 6 days or more a week. So it matters because even though you may not see it, the interpretation and the enforcement of our laws in the way that they were intended by the legislature who enacted the statutes that we follow is important to everybody. And whether you find yourself with a criminal issue where you've been charged with a crime that you may or may not have committed, or maybe you've done something else, maybe that you have been the victim of a consumer scam, maybe you've been the victim of an injury at work. It does matter who's on the court, because when you need them, they have to be ready to answer in a way that is professional and fair.
I kind of disagree with you on one part. I think the people do care about these things. And I remind you, the Washington Constitution wasn't written by lawyers. I mean, fewer than a third of those who sat at the Constitutional Convention were actually lawyers. They were farmers and shop owners and probably newspaper folks, I suspect, but mostly just regular working people. Second, unlike the federal Constitution, which was an add-on, the Bill of Rights was added on at the end, but I always say I'm amused that the politicians told the people, if you ratify this Constitution, we'll give you a Bill of Rights. And one, they actually did it. Who would believe the politicians these days? In the days of our Constitution, they didn't. So Article 1 is our rights. The common sense working people who came to write the Constitution started with Article 1. Now, do they care about the things that I've written about over the years? Private property rights? Well, I had to illustrate it by the sinking ship story, but it could be a Kello, the national case. It could be a little house down the street that someone wants to take because some local politician thinks it's a nice place to run either to build a hamburger stand for his buddy or to run a power line or a road. Free speech rights. They're real important to you. Speak, write, or publish freely on every subject. That's what our state constitution says. Well, you're the published guys. But wait a minute, before we get to that, there's the speak, right, and it does affect most of the citizens. This victims' rights thing that I've mentioned, I think it's real important to people to know that someone's standing up, and the people passed this constitutional amendment, and it almost languished for years because the courts, a piece of it honestly ought to be put on the table, that some of the courts were concerned that if you took too much victims' input, it would be skewing the thing so badly against criminals that it would be disproportionate. That case went to the U.S. Supreme Court. The Supreme Court said no, as long as you do it with balance and make sure that it doesn't violate the rights of criminal defendants. So I think all these things are important. And finally, of course, my initiative and recall. I did those before I got on the court, and I've written about them since. Coppernoll is the case on initiatives. We don't challenge them before they go to the voters because the voters have a right under our Constitution.
Either I didn't ask my question correctly, or you're both answering the question I didn't answer.
Okay.
I wasn't wondering whether the Supreme Court is important. I got up and came in here today. Obviously, I think it's important. What I want to know is why should a voter choose between one of you, other than the fact that you're both on the ballot? What to the voter themselves? Yes, they want a good Supreme Court, but what makes you think, either one of you, that you're the guy they ought to get?
Well, I've represented lots of people under the Crime Victims Act. I tried a case actually over in Idaho earlier this year where my client was shot in the head by a murderer who then took his own life. It was a terrible mess involving complex issues of trust and estate law, which is how I ended up in Oregon or in Idaho on the case. But also, he was blinded in this shooting, and the Crime Victims Act was important to him. It matters that you have somebody on the bench that understands the way these laws impact people in their day-to-day lives. The first obligation, as I said earlier, of any Supreme Court justice is to protect the rights and the liberties of the citizens. And that means protecting them in the courts at all levels. And I've had thousands of people that have come to me for that kind of help. I think that is the type of experience that makes you understand the intent of the laws. The laws are passed by the legislature, presumably for the same reason, to advance the safety, health, and welfare of the citizens of the state of Washington, and they should be interpreted in that way. So when it comes to looking at the ballot and deciding why they should vote for Stan Rumbaugh for the state Supreme Court, it's because I have represented their neighbors and their friends and their people they go to church with.
We can make it easier than that. He and I have talked about two cases today that will illustrate. First, he was critical earlier today about an opinion I wrote in the so-called gay marriage case, Anderson. I wrote in that opinion, going back through the history of Washington, that marriage has always been traditional marriage. And the majority came out 5-4. That's a case that would have changed if Mr. Rumbaugh's theory that we should be doing social engineering by rewriting the Constitution. That case would have changed. I thought and still think that the proper approach is that the people can make decisions either through their legislature or through initiative and referendum. As it turned out, they did both, didn't they? The legislature partially changed the law for the civil, and then it did a referendum. That's the way our constitutional system is supposed to work. Secondly, he's complained today about my SEIU case. Yep, 5-4 opinion, and I wrote the majority. And what I wrote is the courts cannot get into the business, especially when we have a low and declining budget, of ordering the governor to include one union's raises when there's no way that could be done by court order without taking something out of the budget. Now, my view was that was dictated by separation of powers and a legitimate perception of what the power of the court is and is not. We do not have power to write the budget. We do not have power to order the governor to write the budget. And ironically, the case actually came before the court after the first budget had already been adopted. So I plead not guilty, but I plead that that's how I interpret the Constitution. And so there are two cases in which he and I would have made the difference.
Well, let's hear what Mr. Rumbaugh has to say about it. Do you want to get on the court so you can practice some social engineering?
No, I'm not in the social engineering business. The problem with the SEIU case is not that the mandamus statute was or wasn't interpreted correctly. That was a 5-4 decision. That was the narrow issue that was before the court. And whether or not you can order the governor to put in her budget an agreed-upon arbitration outcome or not is a legitimate question.